on whether it's rebuttal or not. Can I see the exhibits, and have we pre-marked them?
No.
If there's no objection, why don't we give them to the court reporter and get them pre-marked?
Your Honor, some of the exhibits that defense counsel is putting in are auto maintenance records, logs about Mr. McCarthy's Chevy Cavalier and when it was in the shop and how it got there.
Okay.
I intend to call the owner of the shop to explain what the invoices mean. It's obviously a rebuttal. There's been no testimony from anybody about any invoices until these exhibits are put in.
Okay.
And so I think it's perfectly appropriate for me to have a witness interpret these exhibits.
Okay, so let's go through the exhibits one at a time, and you can tell me for the record, Mr. Shapiro, what they are.
The first one is a stipulation that the parties stipulate and agree that Michelle Bond began attending the New Horizons Medical Clinic on July 26, 2014, and that her last visit to the clinic was on April 11, 2015.
Okay.
Then the next one is a photograph of Bella Bond.
Okay. So I'm sorry, Nancy, what's these, where are we in numbers?
162 is Bella Bond, 161 was the stipulation, I'm sorry.
And then next is...
I actually, Your Honor, and I apologize for this, it didn't occur to me when we were reviewing the exhibits because I don't doubt the authenticity of this photograph, but it just occurred to me now, I don't know what the jury will make of this photograph if it's not interpreted through a witness in some way. In other words, I'm trying to imagine what defense counsel or I could argue from this photograph in closing, and I'm not sure what a jury could make of that other than, clearly it's a photograph of Bella Bond.
Okay.
But I don't understand, I guess I don't understand the foundation for the exhibit, so.
Can I just take a look at it? So, Mr. Shapiro, we do have a lot of photos already, but in other words, if you're going to be arguing something more than this is a photo of Bella Bond, then I think we need to know that to determine whether some foundation has been laid.
My only purpose is to put in that photo.
Well,
I thought there was an agreement, but there's not.
I guess I object because I don't know who took it, when it was taken, or what.
Well, for example, if there was something about the way Bella looked, I don't know that there is something different here, but let's assume, and I'm not saying this photo shows this, but let's assume there was a bruise on this photo, on her body someplace. I don't see one, but let's assume that. Then you would, if that's why you're introducing it, to show that she had a bruise, then the date of the photo would be important.
Well, that's not the purpose, obviously.
Okay.
Then I guess I object because I don't know what a jury could make of that other than that it's a photograph of Bella Bond, because no witnesses said when it was taken, where it was taken, or anything else.
Well, we can establish from the Facebook page, if Mr. Deacon would like, we can attach the Facebook page which shows when it was taken.
The Facebook page actually shows when it was uploaded, but I mean, is it?
Okay. I don't, Mr. Shapiro, unless I understand the relevance, apart from this is just another photo of Bella Bond, in which case that's not a problem. But if it's being introduced for some additional reason, then the time or place, the date in which it was taken, where it came from, may be important.
If Mr. Deacon is objecting to it, although he didn't a moment ago, then I suppose he's making an issue out of it.
Okay, so I'll sustain the objection.
Should that be match for ID, Your Honor?
Yes.
That would be DD for identification.
The next exhibit is 3 invoices from Donovan Brothers Automotive showing the invoice date of showing repairs to the vehicle, the Chevy Cavalier, on June 1st, 2015, June 8th, 2015, and July 1st, 2015.
Okay, this is where the rebuttal comes in.
Correct.
So that's admitted into evidence.
That will be 162.
Okay.
The next exhibit is a vehicle inspection report dated June 1st of 2015, showing that the vehicle failed the emission test.
Okay, that's admitted.
Exhibit 163.
And then the next is a vehicle inspection report showing that the vehicle passed the emission test on July 28th of 2015.
Exhibit 164.
Then the next exhibit is certified records from AAA showing that the vehicle was towed on May 2nd?
No, May 12th.
May 12th.
Okay.
So, So the first is showing a tow on May 12th of 2015 from Adams Street in Quincy to the Donovan brothers on the Hancock Street, and that's on May 12th.
So that's your next exhibit?
Yes.
Exhibit 165.
And then another tow showing that the car was towed from on June 6th of 2015 from a location on Albany Street in Boston to the Donovan brothers, and that's on June 6th.
Okay, that's admitted.
Exhibit 166.
Is that the revised? Oh, that's subject to revision.
Right. These go together?
Yes.
The next exhibit shows, and this is subject to being revised because there are a couple of errors that need to be fixed, which are being done right now. But the first page shows the service deactivation periods for Mr. McCarthy's phone in May, in June, in July, and in August.
Actually, the August isn't going to be there anymore. That was an error.
No, it's just September.
Oh, September, I'm sorry.
And then an exhibit which shows calls to COSA when McCarthy's phone is in service, and calls, and that's highlighted in yellow, and highlighted in blue, calls to Rochelle Bond's contacts. And this is a period of time from the beginning of May through September.
So would you like that first page as a separate exhibit from
No, I think they go together.
all together?
It shows the deactivation periods.
And then it's followed by...
shows the periods when it was in service.
Okay, as a single exhibit.
Yes.
So essentially these are cell phone records. Is that how we would
Yes.
describe it?
Exhibit 167.
Cell phone records relating to Mr. McCarthy's phone, right?
Yes.
Okay.
And then the next exhibit is the record of Mr. McCarthy's attendance at the methadone clinic beginning in December of 2013 and continuing through August 21st of 2015, showing the daily record of his attendance at the methadone.
Okay.
Exhibit 168.
Okay, so we have 161 through 168 in evidence as described. Now that I hear what the exhibits are and you've clued me in as to this rebuttal witness, I think you are entitled to call that witness. So we'll bring back the jury. I'll inform them of these new exhibits. And then, Mr. Shapiro, you'll state the arresting. And we'll hear from the rebuttal witness at that point.
Yes, Your Honor.
And Mr. Shapiro, I will take your motion for a directed verdict as, well, I guess we can deal with that after the rebuttal. Okay. So that's how I'll proceed. And then we're going to excuse the jury for the day. We'll then have a charge conference. I did receive your request for instructions by email yesterday. Okay, so we'll line them up.
Yes, Your Honor. Jury entering, all rise, please. Justice of the Superior Court, now sitting at Boston, within and for the County of Suffolk, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts and this honorable court. This court is now open. Please be seated.
Your Honor, for the record, continuing the trial of Commonwealth versus Michael McCarthy, docket number 15-11292. All the parties are present and 14 jurors are present.
Good morning, ladies and gentlemen. Thank you for your patience. Before we get underway, again, I want to make sure that you follow my instructions, that you haven't talked about this case with anyone, you've refrained from listening to or reading any news reports. I haven't done any independent investigation as to the law or the facts, and that nothing else has occurred to affect your ability to be fair and impartial. If you have followed my instructions and there's nothing to report, please indicate that by raising your hands. Thank you. In the lull here, before we began, the lawyers consulted, and there's certain exhibits that it's agreed are admitted into evidence. There are exhibits 161 through 168. Mr. Shapiro, I don't know if you want to describe briefly what the exhibits are? Okay, that's fine.
The following exhibits have been introduced in evidence.
And let's just make sure that the monitor for the jury is on.
Exhibit 161 is a stipulation which reads as follows: the Commonwealth and the defendant hereby stipulate and agree that Rochelle Bond began attending the New Horizons Medical Clinic located at 1180 Beacon Street in Brookline, Massachusetts on July 26, 2014, and that her last visit to the clinic was on April 11, 2015. The next exhibit, Exhibit 162, is an invoice. The first page is an invoice showing repair work by Donovan Brothers Automotive located on 610 Hancock Street in Quincy to the Chevy Cavalier, with the due date being 6/1/2015, and then listing the repairs made to the vehicle and the amount of the invoice. The second page of the exhibit is another invoice from Donovan Brothers involving the same vehicle, showing the invoice is dated June 8th, 2015, showing repairs to the vehicle and the amount of the invoice. And the third page of Exhibit 162 is another invoice dated July 1st, 2015, indicating repairs to the same Chevy Cavalier vehicle and the amount of the repairs, with, again, the due date of July 1st, 2015. The next exhibit, Exhibit 163, is a vehicle inspection report dated June 1st, 2015, showing that the vehicle failed the emissions test on that date. The next Exhibit 164 shows that the vehicle, the same vehicle, the Chevy Cavalier, passed the emissions test on July 28th, 2015. Exhibit 165 is a AAA towing record showing that on May 12th of 2015, the same Chevy Cavalier was towed from a location of 24 Adams Street in Quincy to the Donovan Brothers garage. That's Exhibit 165, showing a towing record showing that the vehicle was towed on May 12th, 2015, from 24 Adams Street to Donovan Brothers. Exhibit 166 shows that on June 6th of 2015, the same vehicle, the Chevy Cavalier, was towed from a location on Albany Street in Boston, in Roxbury, to Donovan Brothers. The next exhibit, 167, shows our cell phone records showing the dates of interruption of service on Mr. McCarthy's cell phone on the first page, and then thereafter the exhibit shows between May 1st of 2015 and September of 2015 calls to COSA when Mr. McCarthy's phone is in service are highlighted in yellow, and calls to Rochelle Bond's contacts are highlighted in blue throughout the exhibit. And finally, Exhibit 168 shows the times and dates of Mr. McCarthy's attendance at the methadone clinic to receive a dose of methadone. And this exhibit, as indicated on the top, indicates all of the times that Mr. McCarthy attended the clinic, beginning, I think, with the first date on the bottom, 12/9/2013, and ending.
Actually, I think it goes back even earlier.
Excuse me?
I think if you look at the last page.
The last page.
I thought it went back earlier than even that. It goes into November 2013. If you look at the top.
Actually, the last page seems to start at October 2nd, 2013. October 29th, 2013. And the last date on the first page is August 21st, 2015.
So those
So
are
with these exhibits introduced, the defendant rests.
okay. So we've discussed this, Mr. Deacon. I understand if you wish to call one rebuttal witness.
That's correct, Your Honor. The people of the Commonwealth of Massachusetts called David Donovan.
Stand right here, raise your right hand and face the clerk.
Do you solemnly swear the testimony you shall give this court and jury in the issue now pending between the Commonwealth in the defendant Defarge, to the truth, the whole truth, and nothing but the truth, to help you God? I do. Have a seat,
I
please.
see, sir.
Good morning.
That microphone will help amplify your voice, but just keep your voice up anyway.
Okay, thank you.
Good morning, Mr. Donovan.
Good morning.
Could I ask you please to introduce yourself to the jurors and spell your last name for the court report?
Should I stand, sit?
Stay seated is fine.
David Donovan, last name Donovan.
And how are you employed, sir?
I'm one of the co-owners of Donovan Brothers Automotive at 610 Hancock Street in Quincy.
And who's the other co-owner?
My brother Peter.
So hence Donovan Brothers.
Correct.
Are in fact the Donovan Brothers.
Yep.
How long have you owned that business?
About 30 years.
And do you have, what sort of automotive work do you do?
General repair.
Do you also have a gasoline station or just a,
Nope.
just a shop?
It's just repair, yeah.
Do you know Joseph McCarthy Sr.?
I do.
And how do you know him?
He's been a customer for a long time. We trade. He does plumbing work for me. I do automotive work for him. His shop is one directly across the street from my shop.
How long have the two of you had, by the way, do you have a personal relationship or just a
Not a
business?
personal, but
business?
we've become friends over the years.
And how long have the two of you been developing this relationship?
I gotta say it's gotta be 10 years.
And do you do work on his automobiles?
Yes, I do.
Do you know either of his sons?
I don't really. I've met them, I see Joe Jr. here and there, but I don't really know the sons all too well, to be honest with you.
So your relationship is with Mr. Joe McCarthy Sr.?
Joe, yeah, Big Joe, yeah.
At some point, did he bring, if you recall, a Chevy Cavalier for you to work on?
Absolutely. It was in a few times.
Okay. Do you remember, as you testify here today, when he first brought it in?
I would have to look at the slips.
Okay. Well, let me ask you this, just to see if it refreshes your memory. I'm going to show you what's now Exhibit 166. I'm sorry, Exhibit 165, which is a call detail report for a AAA tow. And it appears to show that a gray 2002 Chevy Cavalier was towed from 24 Adams Street. Do you know that address in Quincy?
I know where Adams Street is. I'm not sure where 24 is, but I know Adams Street.
And it was towed, it looks like, to Donovan Brothers Auto at 610 Hancock. Is that right?
Yep.
And can you see the date of the tow on there?
Is that saying the 12th?
5/12/2015.
Yeah. Yeah, I see that.
So, does that help refresh your recollection as to when the car came to you? It doesn't. That's okay.
Absolutely,
So I'm going to show you an invoice.
Yeah.
And by the way, were you asked to provide invoices in connection with this case?
Joe asked me if I would print off some invoices, so we certainly printed them off.
Joe McCarthy Sr.
Yeah.
And I'm going to show you an invoice. This is part of Exhibit 162. It's dated, it looks like 6/1/2015.
Yeah.
So let me ask you, is it possible, likely, that a car was towed to you on May 12th and not repaired until approximately June 1st?
That seems like a real long time. So there probably was a repair done.
Let me ask you something. But do you have a present recollection of whether there was a repair done after May 12th and before June 1st?
I do not have a present
I'm going to show
recollection.
this witness.
So now I'm going to show you a document and ask you if you would to read paragraphs 1 and 2. Can you see the document?
Yeah, on Wednesday, June 4th.
No. Don't read it out loud. Read it
Oh,
to
I'm
yourself.
sorry.
I think it's to read it to yourself.
Read it.
Okay. Yeah, that makes sense to me.
And does that, just yes or no, does that refresh your recollection about the gap between May 12th and June 1st?
No.
Okay.
Sorry.
But in any event, there is a repair listed here for June 1st. This is Exhibit 162. And there's a description of the work that was done
Yeah.
on there. And does that appear to you to be accurate? I mean, I understand your memories,
Yeah,
but that you would normally list all the things, is that right?
absolutely.
And let me ask you, the June 1st invoice date, what does that tell you about when the work was completed and when the work was paid for, when the car was picked up?
That actually just tells me that that was the day that the bill was written. It could have been 2 or 3 or 4 days after the car was repaired, or it could have been the day of. Again, you know, Joe and I have a kind of a relationship. He's like, fix it when you can, and I bill it when I feel like it, and that type of thing. You know, most of the time it's in and out. You know, it's billed the day of and stuff like that. But we kind of have a casual relationship. He's pretty lenient with fix it when you fix it, and you know. So this just tells me this was the day that the bill was written. And was it the day it was picked up and paid for? It could have been. Is it 3 days after? I don't know. I'm sorry.
That's okay. This work that you list here, how long would that work have taken to do?
This could be a day or two job.
It could be a one-day job?
It could be.
Could be a two-day job?
It could be, yeah.
Any more than that in a normal course?
No. I think what you're trying to get at is how long did the car sit before we did the job, you know?
Just want to know...
Just answer the question. That's a 1 or 2 day job. Sorry.
So it could have been done in one day?
Oh, yeah.
Now I'm going to show you Exhibit 166, which shows a tow, looks to be the same car, from Albany Street in Lower Roxbury to Donovan Brothers Auto.
Yep.
You see the date of that?
6/6, yeah.
Okay, so that's 5 days after that first invoice. Is that
Yeah.
right? And I'm going to show you the second page of Exhibit 162, which has an invoice on 6/8.
Yep, so it looks like the starter failed. We put a starter in.
Okay. And is that one-day job, more than one day
That's
job?
a 1 day job, yeah.
And I should have asked, with the work that was done on this June 1st date, would the car have been drivable without that work done?
No.
Why not?
Alternator would render it inoperable.
And would the car be drivable with the starter defective?
No.
And again, that's a one-day job.
Yep.
Then I'm going to show you the third page of Exhibit 162, which is an invoice from July 1st. You see that?
Yep.
And what repair was done on July 1st?
It's like a right front strut.
And would a car that needed a new right front strut, would that render the car undrivable?
No, usually you can drive a car with a strut, unless the coil spring had broken. But it does, you know, they sell them as it says right there, a complete strut. So I'm assuming it was probably just a noisemaker, a clunker,
And why are you assuming that?
I don't know, just because it's probably a right front strut assembly.
Does your, no, I'm sorry, let me ask you this. I'm going to show you Exhibit 163, which is a vehicle inspection report for what appears to be the same car. Do you do vehicle inspections?
We don't.
So this report indicates that on June 1st, the same day that your invoice is due, is dated, the car appears to have been tested for vehicle inspection. Is that right?
Correct. Yep. That's what it is.
And based on your experience in the auto world, can you get a vehicle inspected if it's not drivable?
No.
You have to drive it in.
You have to drive it in, yeah. Well, actually, they drive it in for you.
Right. You can't tow a car in and have it inspected.
No.
And is it, looking at this review, can you see what, if anything, this car failed?
Looks like all passes to me.
What about up in the emissions result up at the top?
Emissions result, oh, okay, failed there, yeah. Yeah, I didn't see that.
And are you familiar with how, if somebody fails the emissions test, does that mean they can't drive the car away?
No, it means you have 60 days to get it repaired, and then you'll receive a free retest.
And so you can drive it away, you just have 60 days to get it fixed. In fact,
Correct.
does it say that on the document?
Somewhere it would. I don't think it's going to say it on this copy,
Look-
but they give you like 2 or 3 copies.
Let me draw your attention to the first bullet point at the top of the document. Do you see that?
Oh, yeah, right there, okay.
What does it say?
It says fix emission defects within 60 days. There you go.
And I'm going to show you the vehicle inspection reprint, or another vehicle inspection reprint, the Exhibit 164 for the same car. And does that show a result on the emissions test?
Yeah, it looks like it passed on the 28th of July.
And do you have, when you were asked to produce the invoices for Mr. McCarthy Sr.,
Yeah,
you produced all the invoices you had, right?
I believe we did.
So-
The desk girl did them, so yeah, I'm going to say yeah.
So no report, no invoice for repairing the emission system.
Yeah, I didn't see one.
Do you have in your shop the cars that you have that are waiting for people to pick up, like once the repair's been done? Or let me ask you this: cars that are awaiting repairs, is your lot fenced in?
It's not.
So where do you store the cars that are being worked on?
Just on the lot.
So if somebody's car is on the lot and you're getting ready to work on it, if it's drivable, could they just come and take it?
They would have to have another set of keys.
Right, assuming they had a second.
And it would have to not be blocked in, but yeah, certainly if it was parked on the side of the building, yeah, somebody could come by and grab their car, sure.
And if, for example, Mr. McCarthy were to do that, Joseph McCarthy Sr.'s son, would that cause raising the alarms for you?
Yeah, of course it would.
If he took his own car?
Well, if the car was missing.
But I mean, if you then learned that it had been returned. Well, let me ask you this. If it was taken
Yeah.
and then returned overnight, you wouldn't know, right?
I would not know.
And so just to be clear, the times when you performed work on Mr. McCarthy's car that was for work that would render it not drivable
Yeah.
was sometime around June 1st.
It would have been completed by then because the bill was written.
And sometime between June 6th and June 8th.
Was that the second receipt there for the starter?
I can show you again.
Yeah. Yeah, no, yeah, you're correct, because that was the one for the starter.
Nothing further.
Okay.
Hold on a minute.
Yep.
Good morning, Mr. Donovan.
Good morning.
I'm just going to put an invoice on the monitor, which you can look at. And do you recognize this?
Yeah, it's Bagnell, it's a Bagnell Auto Supply slip. Trying to see what the part would be. Doesn't give a accurate description of the part.
It was, do you recognize this? Do you recognize this document?
Yeah, it's one of many. I have.
Okay, does it reflect an invoice that you received for the purchase of a part?
Yes.
Okay, I offer this as the next exhibit.
At this point, foundation wants you.
Okay, I'm sorry, I don't understand. The witness is not entirely clear as to the foundation for me admitting this.
Does it reflect the purchase of a part for a 2002 Chevy Cavalier?
Yes, it does.
Is that the vehicle that you've been testifying about?
Yes.
And does it show when that part was purchased?
It was purchased on the 26th.
Of May.
I don't know that it's the content of it we're concerned about now. It's whether this witness can testify about an invoice generated by somebody else. That's what I'm not clear about.
It was an invoice that he paid.
So you're not objecting now? Okay. Objections withdrawn. We'll admit it.
Exhibit 169.
So is it fair to say, Mr. Donovan, that this reflects a part that you purchased for the repair of the Chevy Cavalier about which you've testified?
Correct. Yeah.
And that part was not even purchased before May 26th?
Correct. That part was purchased 5/26, and there should be a time on it, 9:30 in the morning.
Okay. And so you wouldn't have had the parts to repair that Chevy Cavalier until May 26th?
For that particular job, correct.
Okay, thank you. I have no further questions.
Okay. Thank you, sir. You can step down. You are excused.
Okay.
So any further witnesses?
The Commonwealth has no further witnesses in rebuttal, Your Honor.
Okay. So that means the evidence is closed. The case ended a little quicker than I thought. That we concluded today a little earlier than I thought. I did promise the lawyers that we would have closing arguments no earlier than tomorrow, and there are some things I need to talk to counsel about with regard to my instructions. The closing arguments themselves are going to be lengthy. My instructions are going to be lengthy. So we really do need a good part of the day in any event. I hope you're not disappointed. We're going to excuse you now to return tomorrow at 9 o'clock. And I again remind you not to talk about this case with anyone, not to do any independent investigation of the law or the facts, not to listen to or read any news reports. Stay away from anybody you know to be associated with the case. And we will see you tomorrow at 9 o'clock for closing arguments.
Court, all rise, please. Yours. Step down.
So, Mr. Shapiro, I take it you wish to renew your motion? Renew your motion for a directed verdict?
Yes, we have...
Just give it to the clerk over there. So you did address this motion at the close of the Commonwealth's case. Any further remarks that you'd like to make at this time with this renewed motion?
No, I just would incorporate all the arguments we've made at that point, and
okay. So we did discuss the issues I had questions about. I denied it at the close of the Commonwealth's case. I'm going to do so now at the close of all the evidence. I'd like to, I'm happy to take a morning recess, but we did get a late start, so maybe we can talk about some of these requests for instructions, which I got by email yesterday, and also start going over the draft I gave you a few days ago. Let me turn to first the defendant's requests, which I received first. So, Mr. Shapiro, your first request asked me to vary from the SJC's model homicide instructions, and it relies on a concurring opinion in Commonwealth versus Berry, 466 Mass. 763, in which Justice Gantz, joined by two other justices, observed, if, as we conclude today, a verdict of murder in the first degree based on extreme atrocity or cruelty is not consonant with justice because of the defendant's mental disorder, perhaps we should require the defendant's state of mind always be considered in determining whether the killing is committed with extreme atrocity or cruelty. So you're asking then that I modify the instructions to require some instruction regarding the defendant's intent to inflict extreme physical or psychological pain. Is that correct?
That's correct, but just let me preface this by saying that we object to submitting it, and that we're saying that if the court does submit it, as you indicated that you intended to, we think that the state of the law now is that on this theory of murder in the first degree, that there should be a requirement that there be a showing, proof of intent on the part of the defendant to, as indicated here, that the defendant intended to inflict extreme physical or psychological pain, suffering, or torture on the victim. And so we think that the instruction should include that intent requirement.
Okay, Mr. Deegan, how would you reply to that?
Your Honor, I would suggest that the court adhere to the model jury instruction until such time as the minority opinion of the two justices is adopted by the full Supreme Judicial Court. I think especially since that concurrence arose in a case with a woman with clear mental deficiencies, which I think is the case that pushes the most strongly toward that type of position. There are no evidence of mental deficiencies in this case, so there's nothing pushing this court to go to where the concurring opinion said we should consider. In fact, the concurrence just says perhaps we should consider. So, no disrespect intended to this court, but I think until the SJC instructs justices of the trial court to do that, it's the better practice to adhere to the model jury instruction.
Okay, which is why I read that first sentence from the concurring opinion, because it does talk about a situation where there apparently was a real issue about the defendant having a mental disorder, and then it added that perhaps we should require it, thus indicating that if the SJC were going to expand or extend the instruction to add this requirement of intent, it might very well do so only if there was a real issue about whether the defendant had a mental disorder. So I'm just not prepared to go as far as the defendant would like me to go on that. So I'm not going to vary from the model instructions. The next request also relates a little bit to the Commonwealth's request about prior inconsistent statements. And I do have a section in my own instructions which talks generally about prior inconsistent statements in the context of witness credibility. And I'm now referring to page, let me see if I can find it. I gave you a copy of something that I'd marked up a little bit. It was page 9 of the copy I think I gave you a copy of, where I start out credibility of the witnesses and evaluating the credibility of the witness. There are certain things you can consider, and then going on to page 10, I list them. And one of those categories, the third category, starting at the bottom of page 10, says that the jury should ask whether the witness prior to trial has made any statement or acted in a way that was inconsistent with the testimony the witness gave in the witness stand. And then you see what I have to say there. I think, Mr. Shapiro, your request is very similar to that. So I don't really see anything that it adds. Mr. Deacon does seek to add a little bit more, which is, as I understand your request, Mr. Deacon, you want me to point out that prior inconsistent statements are only to be considered to the extent they help the jury assess the credibility of the witness. In other words, it's kind of a limiting instruction. But then you also want me to go and explain that there may be some other statements that can be used for all purposes, grand jury's testimony and the like. And certainly that's true. We allow into evidence plenty of out-of-court statements under various exceptions. One of them is prior inconsistent statements. There's some other exceptions in which we permit these out-of-court statements, and they can be admitted and considered for all purposes. So, frankly, I've never really honed in on the fine point of whether a jury, or to tell the jury that it's limited in how they consider these prior inconsistent statements, unless there's some important statement that comes in under that narrow exception, and then I'm giving a limiting instruction right at the time. Then it's certainly effective. It's telling the jury, you can only consider it for this purpose, kind of like the criminal convictions. Only for this purpose can you consider this information. I didn't do that in this case for prior inconsistent statements. So now to talk about them seems to be very confusing and require me to kind of give the jury a mini law class on hearsay and all its exceptions, which I'm just not inclined to do.
Your Honor, our proposal there was not that we're insistent that Your Honor instruct in that way. Our proposal there was merely to lay out, for Your Honor's consideration, all the elements that can be incorporated in a prior inconsistent statement charge. But I agree with Your Honor, I don't remember any prior inconsistent statements that were admitted for substantive value, substantially. They were only admitted, I think, for impeachment. So I agree with Your Honor that it may be introducing complexities that are unnecessary from the state of the current evidence.
Okay, there is this interesting request. If, after careful consideration, you find the witness has willfully testified falsely with respect to any material fact, you may disregard all or any part of that witness's testimony, citing Article 12. I'm not sure where that came from. I mean, you see what I was intending to instruct on prior inconsistent statements and credibility of witnesses. And certainly, I tell the jury they can accept all of a witness's testimony, part of it or none of it. So, have I covered the principle, the major points here? And if I haven't, then why should I give this language about willfully testifying falsely?
Well, because I think this is different than a prior inconsistent statement. This is a determination that the jury can make on the basis of the witness's testimony in toto, her demeanor, and everything they've heard. And if they decide, as I think there is a basis in this case to decide, that a witness's testimony is false, is intentionally false, is willfully false, and then I think it's appropriate, and I think it is the law that the jury can disregard all of that witness's testimony. And this is an instruction which I believe, although I don't have authority from Massachusetts in any particular respect, it is a fairly straightforward and common instruction otherwise.
Okay, well, Mr. Deacon, what's your position on this, by the way?
There's no authority from any jurisdiction cited for it. I think it's a fair argument for defense counsel to make, but I think...
So you're objecting to that?
For sure. It's putting Your Honor's thumb on the scale, I think. It's clear to the jury from the instruction on you may disregard some or all of the witness's testimony that they can do exactly this. But this, I think, to introduce a suggestion from the court that if you find willful, that's putting the thumb on the scale.
Okay, I agree. I think I'm going to look at the model instructions on prior and consistent statements and see what else, if I should be adding something more about them. But right now, I'm inclined to stick with what I have, and that section I pointed to, perhaps saying a little bit more about prior and consistent statements in particular. That is, they're there to assess, to assist you in assessing the credibility of the witness and not for any other reason. Testimony of a substance abuser. I was inclined to add something here to my model, the instructions I gave you. Again, going back to the credibility of the witnesses, I talked about police officers, for example. I was thinking about adding a sentence about substance abusers, and I don't have, I'm going to give, I haven't printed that latest version out, so you'll see that. So I'm not inclined to give exactly what you've suggested here, Mr. Shapiro, but I may be willing to say something about it. So just look at what I have proposed on that when you get this second version. I will give an instruction about prior convictions, pretty much along the lines you suggested, Mr. Shapiro. Omissions in the police investigation. So what are you relying on? What evidence here are you pointing to? What arguments do you can certainly argue, by the way, whether I give this instruction or not, that there's been some kind of omissions in police investigation. But I didn't understand that to be at the heart of your case or even all that important to it. But maybe I've just missed something.
I think there were a number of points in the course of the trial where witnesses, police witnesses, indicated that they didn't do things that were standard practice or that they did things that weren't standard practice.
Like, for example, can you remind me?
Well, for example, the witness who testified that the crime scene was not secured after the first search, and that it was open to
the apartment. Oh, okay.
So, I mean, that's one example. Another example is the fact that essentially the police investigation ended on September 18th as to Rochelle Bond when Mr. McCarthy was charged, and she was charged with being an accessory, and that essentially the decision was made at that point as to what the charge is before any investigation of any sense had been done. So that certainly it raises the issue of whether the investigation.
Frankly, the potent instruction I have is pretty neutral and maybe doesn't say what you would like it to say. But let me run that off, and we can speak more specifically to that. Mr. Deacon, what's your position on this?
As to the issues that defense counsel has just put before the court, I would say that it was very clear that the testimony of the officer was that the first search warrant concluded before they received the information that could have led them to freeze the scene, meaning that there was a period of unfrozen scene through no fault of anyone's. which I don't think would trigger a Bowden. I mean, there is, as Your Honor understands, there's no such thing actually as a Bowden instruction. There's no requirement the court give one. And then the rush to judgment issue, I think, is one of those issues that clearly defense counsel can argue it, but it's not something the court should instruct on because there was then a grand jury investigation and further investigation beyond that. So based on what the defense is putting before the court now, I can't see that there's any trigger for a Bowden instruction.
So just the general rush to judgment is not the same as like not
Omissions.
conducting certain tests?
Correct.
Okay, you know, I do have discretion one way or the other. I'm leaning toward not giving it, but I'll run off what I might consider giving, and then we can talk further. Consciousness of guilt. Defendant opposes the submission of any instruction on consciousness of guilt, and I then looked at the the Commonwealth's request, and I had some real doubts as to whether I should give that instruction. Again, these are all this is all evidence that you can point to that you think supports your position, Mr. Deacon, but whether it triggers a consciousness of guilt instruction, I'm not inclined to agree. So, would you like to speak to that?
Yes, Your Honor. I think lying to the police is a classic, it's that and flight are the paradigmatic elements of consciousness of guilt.
But that, I mean, that's an issue. Was he lying to the police?
Right.
I think
and
the defendant's position is that he was telling the truth.
But my point is that given that the evidence can support a conclusion that he was lying, it's important for the jury to understand that they can consider, if they find that he was lying, if they find that he wasn't lying, then the instruction has no force. But if they find that he was lying to police, they can conclude that he was conscious of guilt. Plus, the other items listed on there, I think, are all support an inference, each of them, of consciousness of guilt. So to take that out of the case limits my ability to argue that...
Oh, I don't know. Actually, you can argue all this.
My proposal then, Your Honor, rather than, if Your Honor is not inclined to give the instruction as written, just give the instruction without citing the specific evidence and allow me to argue the evidence. But explain to them that consciousness of guilt is something they can take into consideration.
Well, I wouldn't, in connection with any instruction, go through the specific pieces of evidence that you think show a consciousness of guilt. That does seem like I'm putting the finger on the scale and essentially adopting your position or somehow giving it some validity.
Understood, Your Honor. Some judges are willing to, if you highlight for them what the issues are. Other judges take the same position, and I obviously respect the court's position on that. But I think it's two different issues, whether to give the instruction at all with or without the list, and I understand it would be without the list, or not to give it. And I think there are certainly more than enough things on that list from which I can argue consciousness of guilt. And I think the case law is pretty clear. If I'm entitled to argue it, I'm entitled to an instruction on it. In other words...
So this is unlike Bowden,
right,
where you can argue it even though there's no instruction.
Because the court has said there is no such thing actually as a Bowden instruction. Judges can instruct if they wish, but there is such a thing as a consciousness of guilt instruction. It's part of the model instructions. And I think if the evidence is sufficient to allow me to argue it, it's sufficient to give the instruction. And I understand the court's view on listing the particular items of evidence, but I'd ask that Your Honor give it without that.
Mr. Shapiro.
As we indicate, we object to giving a consciousness of guilt instruction. I don't believe it's required. Mr. Deacon can argue it. Certainly, the court should not comment on the evidence, as Mr. Deacon suggests. So we would oppose giving an instruction. We don't think that the evidence is of such significance that it is required. On the other hand, if the court is going to give a consciousness of guilt instruction, we would request that it give what we have proposed as a consciousness of innocence instruction, which would be equally appropriate given the facts of the case.
You know, where I've given consciousness of guilt is where it's pretty much undisputed. For example, the defendant took flight, when, you know, police tried to arrest him, or that he discarded certain items, or it's the reason why he did that and why he fled is open to debate. In other words, it could be because of something inconsistent with his, completely inconsistent with being guilty. Here, all these pieces of the evidence that you cite, Mr. Deacon, and conversely, with respect to consciousness of innocence as well, essentially require me to adopt one view of the evidence and then instruct him that they can infer from that evidence that he's guilty, or, as Mr. Shapiro says, infer from this evidence that he's innocent. I mean, I have to say, Mr. Shapiro's point is well taken. If I'm going to give consciousness of guilt, then maybe I should be giving consciousness of innocence.
I have no objection to giving consciousness of innocence instruction as proposed. I think that's fair.
Okay.
If I'm arguing, if you're going to instruct the court, the jury, that they can consider, if they find evidence of consciousness of guilt, they can consider it. I don't disagree that they can also tell them if you find evidence of consciousness of innocence, you can consider that too. I agree with that, Your Honor. And I think given where this issue is going to be joined, I think it's fair for both parties to have an instruction from the court that you may consider it the way that each party asks you to consider it, as opposed to saying nothing to them and having them say, what do we make of this evidence? The judge didn't tell us anything about this type of evidence. So I think it's not that they would necessarily do that, but I think...
Although, you know, I think jurors do bring their common sense to their deliberations, and so it's kind of like, I think these are common sense kind of principles.
But I think where the Commonwealth's case boils down to witness testimony, direct witness testimony, and some fairly, what we would argue is some fairly compelling evidence of consciousness of guilt, to not instruct at all on one of the sort of two key aspects of the Commonwealth's case, I think deprives us of the opportunity to be able to say, as the judge will instruct you, you may consider, if you find evidence of consciousness of guilt, as bearing on his guilt. And defense counsel can make the argument with respect to innocence.
Okay.
Well, I agree with Your Honor suggesting that the principles are common sense principles. They're instructed that they can use it. The parties can argue it. I don't think that the court need either way put its primature on that kind of evidence. And so I think that there shouldn't be an instruction either way. But as I indicated, if it's going to be one way, both sides.
Okay, so if I did give one, first of all, I give both consciousness of guilt and consciousness of innocence. I would also make it very general. I'm not going to be pinpointing particular pieces of evidence. So let me think about that rather than rule it out entirely. I think that concludes the defendant's request. Going to the Commonwealth's request, I will include the graphic photographs. I will revise my expert witness instruction to incorporate the ideas in Commonwealth versus Hines. I think I gave you that alternate instruction anyway. I will, okay, we've talked about prior inconsistent statements. I will include the cooperation agreement. Do you see, Mr. Shapiro, what do you have any objection or any comments on the proposal made by the Commonwealth with respect to cooperation agreements?
I think the instruction that the court has given already 2 times is accurate and sufficient. And to the extent that the Commonwealth's suggestion goes beyond that, I would object to that.
Well, does it go beyond it? I haven't matched up word for word. It looks like it contains some of the basic principles here, that I should examine the testimony of the witness who's entered into such an agreement with caution and great care, and that the Commonwealth doesn't know whether the witness is telling the truth, since that's a question for the jury. Is this is drawn from this case, Commonwealth versus Champa? Is that what you're telling me?
Yes, Your Honor.
Okay, and it does, again, I haven't lined it up with the model instructions. I take it it does add additional verbiage there?
That's my point.
You think, okay. Okay, let me look at that then.
And, Your Honor, the Commonwealth is satisfied with the instruction that Your Honor had given. I don't think, if there's different material, it's relatively minor, so,
Okay.
you know,
It's not going to be a big sticking point, okay. Motive, I will talk, that the Commonwealth is not required to prove the defendant had a motive. And you've suggested nicely where I should put this. Thank you very much. I do have something about the consequences of the verdict. I'll make sure that's in there. Mr. Shapiro, if you object to any of these, please say something. Accident instruction. Oh, okay, then we get into the certain things that may or may not be applicable in the SJC's model instruction. So let me just turn to that, because number 9 and number 10 of the Commonwealth's requests have to do with certain parts of the model instruction, which I had a question about, and I just want to get Mr. Shapiro's views on it. Turning then to the handout I gave you a few days ago. Other than specific issues raised by your request, any comments on my general instructions?
No, Your Honor.
Beyond what you've already added?
Right. On the general instruction,
Yes.
when I went through it, there are a number of typos. They're plural and it should be singular.
I'll try to clean that up. Yes. These were basically run-off form instructions that I've used in every case, so I'm sure that's true. I will make sure it's hopefully perfect.
For example, on the reasonable doubt instruction, I think on the 1, 2, 3, the fourth line, there's a but that's left out.
I'm sorry, where?
The term is often used, probably pretty well understood.
Not easily defined?
But,
well, I kind of like to say it that way. I don't think, but, well, that, I will correct all typos and grammatical errors if there are any.
There's also, I think that when you talk about exhibits,
yes,
I think that something should be said about stipulations.
Well, I
that
do,
the
but
jury is required to accept what has been stipulated by the party.
well, I do have on page 4, I talk about what is evidence, and I include, and I just eliminated the brackets there because it applies here, that stipulations are part of the evidence. And in fact, a stipulation, I will kind of state right there, stipulations that actually have been marked as exhibits. Is that what you want me to point out?
Well, I guess the point is, the jury is instructed generally that they can consider or not consider testimony or evidence, or give it the weight that they choose. But with a stipulation, they're required to accept the substance of the stipulation as true.
And that's what I say on page 4. I talk about the categories of evidence, and I say the evidence includes stipulations or agreements of the parties that certain facts are true and therefore need not independently be proven. I think that covers it.
I think that still falls short of saying they're required to accept. That's my only point there. I mean, again,
Okay, I'll just make a note of that if you... I will say something about the view, by the way, and just right there, that, you know, there was a view taken and the observations they made on that view are part of the evidence.
Your Honor, strangely enough, the case law, I think, says, and not that I want to be picky, I think the case law says the view is not evidence, but that they may use the observations in evaluating the evidence. And I've never quite understood what the distinction is there, but that's my understanding, is that technically the view is not the taking of evidence. It's just giving them a view, and then they can as they're evaluating evidence, refer to what they've seen. But that's a picky point. But
Okay, I thought I looked at the instructions in the view, and it said the observations that you make on the view are part of what you can consider in reaching a verdict.
it's a weird thing, but I think that's a correct statement of the law, but I'm not sure it's technically evidence. So
Well, maybe I can just
you finesse it.
finesse it
Yep.
and say they had a view, and the observations they make
Yep.
can be used
Yes.
as part of their deliberations.
Yes.
Mr. Shapiro, are you okay with that?
Yeah, I'm fine.
Okay. So I will insert, with respect to testimony admitted for a limited purpose, criminal convictions, and I will insert the graphic photographs where you suggested. Did you see my instruction about the defendant not testifying, Mr. Shapiro? And what did you think about it?
What page is that on?
I gave you a separate page. It was not in the packet of general instructions. It was a separate page entitled "Defendant Does Not Testify." By the way, I wouldn't include that caption in the instructions.
That's fine.
Okay. So I'd probably insert that where I indicated, right before direct and circumstantial evidence. We've talked about the credibility of the witnesses, and I'm going to add something about substance abuse. I will alter the expert witness instruction a bit, and I will include under exhibits something about the graphic photographs. And by the way, you may have noticed in my general instructions, my closing instructions, that I do something that only a few judges do, but I've been doing it for quite a while with good results, which is I allow the jury to pick their own foreperson. I don't do that if you object, because the law does say that I'm supposed to pick the foreperson. The reason I have adopted that practice is, first of all, I think the jury knows each other better than I do. I also am concerned that to the extent I pick somebody, I am going by certain kind of stereotypes, unconscious or conscious biases. I don't want to try to pick somebody that might reflect some opinion I might have about the case. So I feel like I avoid all that by having the jury select their own foreperson. If you look at my instructions, I do tell them not to take too much time on this, and in the event they got stuck on that, I would appoint somebody. I've never had that happen. They've always selected their foreperson pretty quickly. But I would like to know, if you object to me doing that, then I will pick the foreperson because I don't want to create some kind of error.
And where are the...
I explain all of this in on page 14. Let me see. Last page. After reducing the jury. And by the way, I would not pick the foreperson, if I did pick one, until the jury was reduced, which is another reason I don't like to pick forepersons, because sometimes I'll pick somebody, or I have some idea in mind, and then that person is the alternate. In any event.
I mean, usually the foreperson is excluded from the draw.
I know, and I feel that also perhaps allows, again, I feel that's me intruding on the process somehow. But if you would like me to pick the foreperson, Mr. Shapiro, I will.
I just need to think about it for a moment.
Okay, Mr. Deacon, what about you?
I have no objection to Your Honor following the practice. While Mr.
I mean, doing this odd thing that some judges do. Okay.
The court's reasoning sounds, frankly, persuasive to me. So, I did want to raise one issue. I said there were no issues. It's not an issue with the instruction, but for the sake of clarity, on page 44, there's a line.
40. What page?
On yours, page 44, Your Honor's instructions, of the general instructions.
I didn't know I had 44 pages. I think you're
Oh, it's
looking-
in the substantive law. The
Oh, no,
final-
we haven't gotten, the SJC
Oh.
model instructions?
Yes.
We haven't gotten there yet.
Thank you. Sorry.
Okay, let's talk about that. Okay, so Mr. Shapiro, let me know. If you want me to pick a foreperson, I will, and I'll do it before I reduce the jury. Okay?
All right, we don't have any objection to your doing it the way you suggest.
Okay. So I'm going to be instructing on murder in the first degree, deliberate premeditation, and extreme atrocity. I have eliminated, there's no evidence of self-defense, defense of another, and there is no evidence of mitigating circumstances, those mitigating circumstances being, as I understand it, heat of passion, reasonable provocation, and that kind of thing. Right, Mr. Deacon?
I'm sorry, Your Honor, I apologize.
I'm looking at the SJC model instructions on murder.
Oh, yes. No, I agree. I'm
Okay,
sorry, Your
so
Honor.
I'm
I
not
heard-
going to,
yeah.
and Mr. Shapiro, if you disagree anywhere, let me know. So I wasn't going to be instructing on evidence of mitigating circumstances. I then will instruct where there's evidence of accident. It says if you have a reasonable doubt as to whether the victim's death was accidental, because the death was an unintended consequence of an intentional act or was caused by negligent, careless, or mistaken act of the defendant, etc., you may not find the Commonwealth has proved this element of an intent to kill. So I will include that. There is no evidence of transferred intent, so I'm Xing that out. So that brings us to page 40, where there's evidence of mental impairment or consumption of alcohol or drugs. I think the Commonwealth indicated that to be on the safe side, I should perhaps instruct on this?
No, our position was, Your Honor, that I think it's a close issue, I think, but on the overall state of the evidence, if the defense wanted such an instruction, we would concede that they were entitled to it.
Okay.
So we're basically saying, I think that's really the defendant's call.
Okay, so Mr. Shapiro.
We're not requesting any instruction.
Okay, so I won't give any instruction, and you're saying, Mr. Deacon, if the defendant doesn't request it, and I take it, and that's part of your strategic view of the evidence, you're making this decision, Mr. Shapiro. In other words, I don't want to raise any question about some instruction that should have been given but wasn't requested, and that somehow introduces some appellate error.
That's correct.
So this is a strategic decision on your
It
part?
is, yes.
Okay. So I will eliminate that. Self-defense, mitigating circumstances, we talked about. Okay. So now I get to murder with extreme atrocity or cruelty. And here I'm Xing out on page 44, pretty much that whole page, self-defense, evidence of mitigating circumstances.
Your Honor, just for the sake of clarity, we actually didn't get page 43. I assume that it's essentially tracking the model instructions, and I assume that on page 43, the court intends to discuss the first element, causation. We just couldn't tell, because our copy jumps from 42 to 44.
Oh, I'm sorry. Okay. You mean, you're telling me I omitted a page?
Well, I think it may have been a copying issue, not a...
We didn't get 43.
You didn't get 43 either?
No.
Okay. I did. So, yes, at page 43, I would instruct. It basically gives the elements of murder by extreme atrocity or cruelty. So essentially that, and what I'm going to do, by the way, is run off a second version here that you're all going to have a chance to go over line by line, and we can review later, giving you that time, sometime today, but giving you that time. So I don't see any changes to be made to page 43 of the SJC's model instruction. It's only when I got to 44 of the SJC's model instruction that I did feel that that whole page goes out, except, wait a minute. I'm sorry. No, it's number 4 and 5 go out. The top 2 paragraphs on page 44, and then it says, I will now discuss each of these requirements in more detail. So that all stays in. The first prong, the second prong, the third prong, that goes into 45. I'll just give that. Then we go to 46. Here again, we have evidence of mental impairment or consumption of alcohol or drugs. Mr. Shapiro, this is the same issue here with respect to extreme atrocity or cruelty. You're not requesting that instruction.
That's right.
Okay. Okay. So then I pick up on that page. The third element is that it was committed with extreme atrocity or cruelty. So I'll give that instruction as the SJC is recommended. That goes into 47, 48. And the only time I make any changes is to come to page 49. And there's the mental impairment again. X that out. Self-defense goes out. Mitigating circumstances goes out. Felony murder goes out entirely. I didn't even give you those pages. Then we come to murder in the second degree. 57, unchanged. 58, eliminate self-defense, mitigating circumstances. And then we come to essentially the difference between, these instructions basically point out that the murder in the second degree has the same elements as murder in the first degree with extreme atrocity or cruelty, except for that third element, that the killing had to have been committed with extreme atrocity and cruelty. Felony murder in second degree, that's all eliminated, so 59C63 is eliminated. So is any instruction in voluntary manslaughter. So that comes to involuntary manslaughter. And I know you objected this, it's a submission of this, this instruction, Mr. Shapiro, but Mr. Deacon, you indicate that the Commonwealth wished to proceed on both theories of involuntary manslaughter, is that correct?
Yes, Your Honor.
And is it like murder in the first degree, that is where you have different theories? There has to be specific unanimity as to the theory?
I don't know, Your Honor. I believe so.
Mm-hmm.
I think it would.
Okay. Well, certainly that would be the safer course. I wasn't entirely clear on that myself. But that would mean the verdict slip would then have these two categories,
Right.
and tell the jury pretty much the same thing I told them about the two theories on murder in the first degree, that they can pick one or both. But if they pick neither, if they can't agree as to either one, then essentially they can't find him guilty of involuntary manslaughter, in this case at least.
I agree, Your Honor.
So we then get into each theory. First, involuntary manslaughter caused by wanton and reckless conduct. Again, no evidence of self-defense, so that goes out on page 75. And there are lengthy instructions here. 79, again, reference to self-defense, defense of another. There's no the Commonwealth's not alleging the defendant failed to act.
No, Your Honor.
Okay.
It's not a parental rights sort of situation.
So all that those instructions go out, and that covers part of 79, 80, 81, 82, 83, 84, 85, 86. And then we get to involuntary manslaughter unintentionally caused by a battery. Again, I eliminated self-defense, page 88, and also page 90, self-defense, defense of another. There's then supplemental instructions. I don't need to get into the definition of death. That's not an issue, right? Object of the killing must be a human being. That's not an issue here. Use of a dangerous weapon. That's not an issue here. And then we have the chalk, which I'd like to give to the jury. I'm going to give them the full copy of my written instructions. I'll probably give it to them at the time I'm reading them, since studies now tell us that, contrary to our initial beliefs, that juries actually comprehend better if they can listen and read. So I was going to give the written instructions to them at the very beginning. The question is how and when I use this chalk as to the elements of murder in the first degree, murder in the second degree, and involuntary manslaughter. Does anybody have any suggestions about that? I think a chalk is helpful.
I do, Your Honor. I would propose to give them the chalk when you're giving the general instructions, because I think if they can follow along, it fends off questions later on. And I think it's more useful to them, as you say, if they see it while they're hearing it, so they can mentally map Your Honor's instructions. I would note that the chalk will require some
editing, sure.
because of the voluntary manslaughter, absent murder charge, and some of those things. But
now that I've actually gone through and discussed, what's relevant and what's not, can I ask the Commonwealth to prepare an edited chart?
Certainly. I don't know. Does Your Honor have a digital form of this chart?
Yes. I thought you did too.
We think we already have it, so we can certainly prepare an edited chart.
I mean, it just, if you can take that part while I'm working on finalizing my instructions, what I'd suggest here, so it's 11:45. I think we've covered all the relevant issues that we need to discuss. Let me just ask, have we covered everything?
From the Commonwealth's perspective, Your Honor.
Mr. Shapiro?
I believe so.
Okay. So now what I need to do is implement those suggestions and then give you a new draft that we can then review. There's a couple of issues I'm a little bit on the fence about, and we can resolve those in the context of this further draft. So what I'd suggest is coming back at 2 o'clock as soon as I have something, and I hope to have something in the next half hour. I will make hard copies available. I can also email you. But
if we're coming back at 2 o'clock, I'd be grateful for an email, because I think I'd go back to my office.
the other, I want to make sure you have time to really read this. So would it make sense to make it 3 o'clock? I'm thinking that would give you plenty of time to read it. Give me time to finalize it, and then give you a good hour or so to read it, and then come back for any final comments at 3 o'clock. How about that?
Sounds good, Your Honor.
So you're going to email it to us?
I can, yes. And would that be, I can make hard copies available here, or I can also email. I can do both.
Email would be preferable, Your Honor.
Preferable to email?
I would like that, yes.
Okay. I will do that. So hopefully I can get something to you in the next 30 to 45 minutes, and then we'll reconvene at 3 o'clock. It's pretty much as we discussed, except for a couple of these issues that I've either reserved judgment on, or I said I am going to put something in, for example, about substance abusers, but you haven't seen what it is I'm going to put in. So we'll see you at 3 o'clock then.
Court, all rise, please.
Oh, I'm sorry, there is one issue, there is one issue that I need to discuss before we take a recess. And that has to do with the humane practice instruction. I know you didn't request any humane practice instruction, Mr. Shapiro, and there may be very good reasons for not doing that. However, in the course of your cross-examination, you did raise questions concerning the medical record of Mr. McCarthy when he was hospitalized. I don't know if that makes it a live issue, and I don't know, again, I need to know what your position is on this humane practice instruction.
We're not requesting it.
Okay, and is that because that would to some degree undercut your position with respect to this statement he made to police?
Because we think he told the truth.
Okay.
And there's no reason to suggest that he was somehow forced to tell the truth.
Right. That would be inconsistent,
Right.
basically, with that position. Okay. I think there's actually a case in which this came up and the argument on appeal was that the failure to request it was ineffective assistance of counsel, and there the court made the same point you did, which was it would have been wholly inconsistent with the defendant's theory of the case to have requested it, and so therefore it couldn't have been an effective assistance of counsel. But I just wanted to make sure you thought about the issue, and it's on the record that you do not want it.
Correct.
Okay. Okay, let me just look at my notes and see if there's anything else I've missed here. Let me just ask this. You know, the defendant is not charged with accessory after the fact. That is, that if he had disposed of the body and hadn't actually participated in the killing, that he wouldn't be guilty of the charge that he faces now. I don't know if anybody wants me to say anything about that. Mr. Deacon, you don't want me to. Okay.
No.
Okay. It introduces more complications, I guess, than it's worth. Okay. So we'll take a recess, and I will email you my instructions.
Court, all rise, please. We're in recess till 3 o'clock. Thank you.
And in fact, I left some instructions on your tables there. So let me start with Ms. Deacon. With regard to any of the proposed changes or additions that I've made, specifically those things I've added by italics, or anything else you want to comment on as to the instructions in this draft?
Your Honor, just they're really only at the level of sort of the typographical, so I don't know if you want to address that.
That's fine. I have various people reading this to make sure I get all the typos.
Page 2, fourth line from the bottom, there's a "the" missing. It says that the defendant is guilty beyond a reasonable doubt.
Okay.
Page 3, near the second line from the top, it still has the plural charges.
Yes, I saw that, yeah.
Page 3, toward the beginning of the last paragraph. What? Oh, you had a comment. Yeah, well, there should be a comma after probability.
Okay. We can debate commas. Always a subject of debate
Right.
among reasonable people.
Right. On page 4, where it talks about stipulations or agreements,
Yes.
it should be plural.
Okay.
And let me also tell you what is not evidence.
Oh, yep, I saw that, yep.
Then page 6, second paragraph down, it should say, just as I have told you what is not evidence.
Oh, yep, again, I don't
Yeah.
know, the spell check missed, yeah, okay, what not evidence is.
Okay. Page 10, no. Yeah, page 17, there's a stray paragraph there.
Yes, I
Just-
saw that, yep, cross that out about the mitigating circumstances.
Page, let's see. I'm sorry, I'm actually flipping through because I didn't make a note about all the, that's it.
Okay, more substantively, before we talk about the two issues I kind of left open, do you have any comments? For example, I have a line there about substance people use drugs. I have the view. I have criminal convictions. I did just go ahead and adopt your language about the cooperation agreement, but I may, in rereading it, it's kind of wordy. I may try to tighten it up. I know Mr. Shapiro wanted me to use the model, but I kind of For ease, I just adopted yours. I also added your instruction about motive and about how they shall not consider the consequences of the decision.
I'm looking for the one on the drug. I'm sorry, I'm trying to find the page that has the drug user.
I think it's around 9 or 10. I talk about the credibility of witnesses.
Yeah.
And I added a section on page 11.
Yeah, I think that's a reasonable instruction, Your Honor.
Okay. And I also tried to explain to the jury a little differently than the model instructions about, these different theories and how they can pick one or both, but they have to unanimously agree, and if they don't pick either, then they go to the lesser charge. And I italicized all that because it was a little different than the way the SJC had described it. So just make sure you take a look at that. I also changed the expert witness instruction, as you suggested. Okay, so before we turn to the open issues, Mr. Shapiro, do you have any comments?
Yeah, I have a few.
Okay.
Some of them are mere typos, but
Yep.
On page 2, the fourth line, indictment should be singular. Against this defendant is rather than
Yep.
are.
Okay.
No more than an
Yep.
accusation singular. First line of the second paragraph, innocent of the charge, singular.
Yep, thank you.
I think on page 6, the middle paragraph, it's okay.
What not, I see that, what not evidence is that what you're referring to?
Yeah, well,
Yep.
you've already caught that. Then on page 9, the last full sentence, I have a problem with. If there are differences in the testimony of different witnesses, you must resolve those differences. You're telling the jury they have an obligation to resolve the differences. I don't think they. I would leave that line out because I just don't think either that or say you may or may not be able to resolve them. But if you give them the obligation to resolve them, who knows what they're going to do.
Okay.
I don't think that's then I don't know if we're getting into substantive here, on page 15, when we're talking about only if you unanimously agree that the Commonwealth has proved one or both theories. I would add you must be unanimous with respect to each theory.
Okay, so I'm sorry, where are you on page 15?
This is 1, 2, 3, the fifth line down in the second full paragraph.
On page 15?
On page 15, yeah, only if you unanimously agree that the Commonwealth has proved one or both theories. I think that's a little ambiguous.
So what would you say?
I would add, you must be unanimous with respect to each theory.
Before they can actually check the box, in other words? Is that, okay, I'll certainly consider trying to clarify that.
Then on page 17, you have the paragraph, the first paragraph, if you have a reasonable doubt as to whether the victim's death was accidental, because the death was an unintended consequence of defendant's intentional act, or was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find the defendant has proved this element of intent to kill the victim. Well, I think that's an instruction that is relevant to all of the charges against them. Because if it's accidental, it's not second-degree murder. If it's accidental, it's not involuntary manslaughter. So to only give
So
it-
maybe at the very end, just kind of put, for example, I have something at the very end about motive, how that's not an element of the case. Then I could put generally that with respect to any of these charges, if they have a reasonable doubt as to whether her death was accidental or was caused by negligence or resulted from a cause separate from the defendant's conduct, then the Commonwealth would not have proved
would not have satisfied their obligation to
to
prove
prove
guilty beyond a
defendant guilty of any
reasonable doubt.
crime, of any of the crimes listed on the verdict slip, basically.
Mhm.
I think he might have a point about that, Mr. Deacon. I think I agree.
I do. I
Okay.
agree.
Okay.
If it was accidental, it's not a crime.
Okay, so I'll figure out a way to, I think the way to do that is probably at the very end and say, if they have a reasonable doubt as to whether it was an accident, et cetera, then the Commonwealth will not have sustained its burden as to any of the options in the verdict slip, and you must find the defendant not guilty.
Yeah, and
Right?
he must return a verdict. in that
Yeah.
case.
In that case, Your Honor, I would ask that Your Honor give it in one place or the other, but I don't think it's, the intent element, the second element is that the defendant intended to kill Bella Vaughn, that is, the defendant consciously and purposely intended to cause Bella's death. I don't think it makes sense to instruct on accident here and then instruct on it generally again.
No, I would do it as to, at the end, as to just not put it here, put it at the end,
Fine.
since it all, but you would agree that even as to involuntary manslaughter, even though that doesn't require intent,
Yes.
it does mean that if it was accidental, or if it was negligent, or resulted from a cause separate from the defendant's conduct, then you cannot be guilty
Agreed.
of involuntary manslaughter either.
That's right.
Okay, so it applies to all options.
Then, just for the record, I would request, I believe the court has discretion but is not required, to add to the first degree deliberate premeditation a cool reflection. That is the statement that they must find that the defendant decided to kill after having an opportunity for cool reflection. That, of course, has been part of the case law. The SJC has said that's not required, and the failure to give it in a recent case did not result in a likelihood of a miscarriage of justice because it wasn't objected to, the failure to do it. But I think the law is that the court has discretion to give it, and I would request that.
So the addition of cool is what you want me to add there?
Right, that is, as an element of deliberate premeditation, they must find that the defendant decided to kill after having an opportunity for cool reflection.
Or after a period of cool reflection. Okay, and what's the case law for you? Say that case law is that I have this.
There's Commonwealth versus Leclerc, 429 Mass 313, which discusses, that particular instruction.
I would argue, Your Honor, that your instruction says he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process, and it lays that out. I'm not sure that I agree that cool reflection is required, only the period necessary to focus the mind's intention on killing. I understand the case law, but I think that the way Your Honor has laid it out makes it clear to them that you have to have had the period of reflection necessary to form a decision to kill. But cool reflection, I think, actually only applies to a subset of premeditated murders. That is, premeditated murders that are carefully planned out, and the law is clear that it doesn't have to be carefully planned out. It can happen over seconds. The key issue is whether the mind has focused an intention to act. And so I would ask that Your Honor just leave the instruction the way it is.
Okay. Well, I took this right from the model. I'll look at the case you cited and consider your argument.
Okay. The other, again, this is for the record, I know, and this is with respect to extreme atrocity or cruelty, we would ask that the court require unanimity with respect to any particular factor. Now, I know...
You mean as to any particular prong? Or the Kunin factors?
Kunin factor, right. Now, I know there's recent law saying that that is not required, but for the record, I'm making the request that you include that.
Okay, that's noted. I'm not going to instruct requiring that.
And again, on page 22, and this would be in the middle of the second paragraph, where it says, you may find the defendant guilty of involuntary manslaughter only if you unanimously agree as to which theory or theories. Again, I would say it should read only if you unanimously agree as to each particular theory.
You know, my only problem, okay, is they must unanimously agree that you mean that the Commonwealth has proved its case. In other words, if they unanimously agree that the Commonwealth has not proved its case, or if, in other words, unanimity, you can have disagreement among them, not unanimity as to either theory, in which case you don't have a verdict as to murder in the first degree.
Yeah, I just think it's a little ambiguous to say theory or theories, because they might think if, 6 agree on one and another 6 agree on the other, and they could be 12 for each, but they might not be the same 12.
Okay, so I'll see what I can do.
Could I suggest saying only if you unanimously agree as to one or the other theory or both? Because they can do either of those things.
But I think that's confusing as well.
Okay, it's kind of confusing anyway, but I'll struggle to make it as clear as I can. Noting that you don't like what I have, neither. Maybe I can do better. Okay.
And just the fourth line from the bottom. You may conclude that the Commonwealth has proven both theories.
Or only one of them.
Right, should be
Yeah.
more.
You may also conclude, this is where I tried to spell it out. You may also conclude that the Commonwealth has proved neither theory, in which case you must find the defendant not guilty. Okay.
I think that's... Okay. With respect to the cool reflection, the more recent case is Commonwealth versus Felix, and that's 476 Mass 750. And then there is the typographical error on page 36. The last line of the second paragraph, deliberations and misspelling. Did you see that?
Where is this?
On page 36, you were not to indicate to them at any time what you were talking about or where you stand in your deliberations. That's misspelled.
Okay.
Just a typographical error.
Oh, I see, yeah, okay. Okay, so So let's talk about, I've been thinking about the additional instructions. Consciousness of guilt, consciousness of innocence, and the Bode instruction. And first of all, there is pretty clear case law that there is no consciousness of innocence instruction. I'm looking at 425 Mass 378. We have previously not required a judge give a consciousness of innocence instruction. And that was in and they listed a whole string of citations actually in the case of Commonwealth versus Pena, 430 Mass 266, which found no error in not giving it. And in that same case, it says the defendant now invites us to revisit the question and relies on some kind of dissenting opinion from the Supreme Court. We hold that consciousness of innocence is a subject properly left to the give and take of argument without jury instructions. And I'll tell you, my problem with both the way the Commonwealth phrases its consciousness of guilt request and the way the consciousness of innocence instruction is phrased is that you're taking particular pieces of evidence and seeing it or having it characterized from two different perspectives. So on one hand, Mr. Shapiro sees that the defendant was cooperating with police, and another view of it was that he was making certain misstatements in his interview with police, and that's consistent with consciousness of guilt. I think the only thing that can be and a lot of these really go to the heart of the crime itself, whether the defendant was involved in disposing of the body, whether he took a trip to the reserve channel, whether he made the statement about her Bella being possessed by a demon. Those are all in contention, and it seems odd to pull those out and say, well, if you view the evidence this way and you believe certain testimony, then you can infer from that some kind of consciousness of guilt. I think the one thing that is legitimately before the jury is the position the Commonwealth is taking as to certain certain statements the defendant made to police. For example, his girlfriend is Kathleen, that he slept on Rochelle's couch, certain statements in that interview, which, if the jury finds those to be false, could possibly provide a basis to infer that he had something to hide. So, looking at the model instructions, I gave you a proposal which essentially focuses in on that, the false statements allegedly made to police. Do you have that? Let me make sure I have. Yes, it's additional. You see the piece of paper I gave you, additional jury instructions. So that's what I was intending to capture. It is balanced, of course, by stating that, first of all, it's up to them to decide the facts, and standing alone, such evidence, even if they were to find these statements not to be true, would not be enough to convict a person of a crime, and they cannot find the defendant guilty on such evidence alone, but are to consider it.
Could I?
So I'm inclined. What?
Your Honor, my request, and we had already conceded that if Your Honor is not inclined to pull out specific evidence, that's fine. But I would ask not to limit it to this. My suggestion.
Well, how do I phrase it? Because the model instruction does basically contemplate the judge talking about some specific piece of evidence,
right,
like the defendant fleeing.
Could I suggest that Your Honor say the Commonwealth has introduced evidence that it contends indicates feelings of guilt by the defendant. If the Commonwealth has proven that the defendant did things that indicate feelings of guilt, in other words, do it that way, just sort of because the model jury instruction does as Your Honor says, contemplates the Commonwealth being able to argue that certain actions, which I've laid out for you, are in fact consciousness of guilt. Lying to police is a classic form of consciousness of guilt, but the case law is replete with items of consciousness of guilt that are not lying to police or flight. And I understand that Your Honor doesn't want to pull out and say these are the things the Commonwealth says he did that indicate consciousness of guilt, but restricting it to just making false statements before his arrest makes it sound like the other things that we allege show consciousness of guilt, like going to the dump site the day after the body was recovered in Winthrop. Clearly, if believed, if the jury credits our argument that the day after Bella's body was found, he went to the place where he could get a view of the place where it was dumped, they could conclude that he was displaying consciousness of guilt. So I guess I can understand not wanting to list all the items, but I also think restricting it to one is it unduly limits the Commonwealth's argument. And it makes it sound as if this is the only thing you can consider as consciousness of guilt, which is not a correct statement of the law either.
Okay, tell me what you, hold on, Mr. Shapiro, let me just finish it. What is it that you ask I say then? Exactly. If I'm not going to say false statements, and that is kind of the classic, and it is something actually, in this case, there'd be all kinds of argument, and in fact these particular points are vehemently argued as to whether he disposed of the body, whether he made a trip to the reserve channel, whether he called Bella a demon. That really goes to the core of the Commonwealth's case. That's not necessarily consciousness of guilt. That is, was he participating in this crime in the way the Commonwealth alleges?
But I think it's abundantly consciousness of guilt. If someone disposes of a body, we can argue that it shows consciousness of guilt toward the murder itself. In other words, that's
if you find that to be true, that he did it.
Agreed. But my point is, Your Honor, if you stated to say the Commonwealth has introduced evidence that it contends indicate feelings of guilt by the defendant, period. If the Commonwealth has proven these things, and I'm sorry, I'm trying to do this on the fly.
If you credit, or if you
right, if you credit this evidence, and you conclude that such feelings of guilt might tend to show actual guilt on the charge of murder, then you may consider such evidence as consciousness of guilt. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of this case. If you decide, so in other words, just state it in a general, the Commonwealth has introduced evidence that it contends indicates feelings of guilt by the defendant, period. If you credit this evidence, and if you conclude that it indeed shows feelings of guilt, then you may consider whether such evidence tends to show actual guilt on the charge of murder.
Why don't you put that in writing and send it to me by email?
Yes,
so, Mr. Shapiro, you want to say something?
I don't, given what you have just pointed out, they really, I think there should not be a consciousness of guilt instruction. Everything that the Commonwealth is suggesting, or will suggest in its argument, go to whether or not the defendant committed the crime. Now, if they want to argue that certain elements of the crime, in addition, suggest a consciousness of guilt, I think it's pretty ridiculous to say if you dispose of a body after killing somebody, that shows you're guilty any more than killing that person shows you're guilty.
Well, I guess what the Commonwealth is saying is that if you all agree that he disposed of the body, then that is some evidence that might assist you in determining whether he was the person who killed the child.
Well, obviously, we're not agreeing on that. So.
I understand that.
And there's no agreement as to any of these suggestions that the Commonwealth makes. The idea that there were false statements, I think that's pretty ridiculous given the statements to Trooper Balducci. But I certainly don't think that the court should identify any particular pieces of evidence, suggest that there is evidence of such a thing. I just don't think there is. If the Commonwealth wants to argue it, fine, the Commonwealth can argue it. I can also argue the consciousness of innocence in cooperating with the police. But to put your finger on the scale and say, well, I'm going to instruct on consciousness of guilt, but I won't instruct on consciousness of innocence, I think is a disparate treatment of the defendant.
Well, except the case law does not support a consciousness of innocence instruction.
Well,
I just cited it, and it does support a consciousness of guilt instruction in appropriate cases.
Yeah.
So I'm saying it's not a question of favoring the prosecutor, Mr. Shapiro. I'm trying to follow the law.
Well, the law gives the court discretion, and given the circumstances of this case, and given the evidence in the case, and I think a wise and prudent exercise of discretion would be not to instruct on consciousness of guilt and leave it to the jury to infer what they want based upon their own view of the evidence and their experience and common sense, and to not allow in what I suspect, well, I suggest, is a very weak case to give the Commonwealth a leg up by instructing on consciousness of guilt.
Okay. So I'll consider those arguments. See if you can put your proposal in writing, Mr. Deacon. The only way I would consider it is if it was general in nature and where I didn't indicate in any way that I was accepting this evidence as true. But if you can come up with something that avoids those pitfalls, I am going to consider it. Now, on the Bowden instruction, I am inclined to give that on further reflection. Specifically, it's not necessarily, or maybe I'm wrong. I thought the Bowden instruction I have proposed here talks about failure to perform certain tests or to undertake certain steps. From what I understand, Mr. Shapiro, your primary argument here is that by failing to continue to investigate, like having just rushed to judgment, accepting Rochelle's word, failing to go further in the investigation, that's the point you're trying to get at,
Yeah.
right? So I would just simply say the failure of the police to undertake certain steps.
I agree.
And then go over the considerations they're to make.
Your Honor, based on what defense counsel listed, the steps, I think he said one step was that they didn't freeze the scene after the first search warrant and before the second search warrant. And I can't remember the second one they said.
The second one was that Rochelle comes in, gives her story, and that's the end of the story for the Commonwealth. In other words, they didn't undertake further investigation.
I think that's not specific enough. In other words, I think defense counsel should have to say what specifically he's pointing to in order to justify a Bowden instruction. Because I think just saying generally they didn't do enough is, I mean, what we have right now is...
Well, I'm not going to say anything in the specific...
No, I'm not saying Your Honor will, but I'm saying for the defense to warrant a Bowden instruction, I think you should have to articulate something other than the failure to freeze the scene between the first and second search warrants. And that's really all we have. We have that, and they didn't investigate. So I think defense counsel should have to make more of a showing than that to warrant a so-called Bowden instruction.
Okay. I'm inclined to give it. I'm inclined to give him consciousness of guilt. I'm also inclined to give the Bowden instruction. With respect to how these instructions are going to be given, hearing that the closing arguments may take an hour or more, and knowing my instructions are going to take an hour or more, I was considering doing something which some judges have already started doing, namely breaking up the instructions. And giving, for example, perhaps the general instructions first about reasonable doubt, presumption of innocence, and everything else in that section I call general instructions. A couple of them are case-specific. They talk about the plea agreement, and they talk about substance abusers, and they talk about prior convictions, but otherwise it's general. Then have the closing arguments, and then after the prosecutor's argument, go into the specific instructions. So I'm not just talking for an hour and a half. That's one proposal. I think if I didn't do it that way, what we're left with is the closings in the morning, a break someplace probably between the closings, coming back, and then I can give it as a big block In either case, however I divide it up, I think we are likely going into lunch to past 1, or I could, take a break before I give the specific instructions if I break it up like I just suggested, and do it after the jury has lunch upstairs. So I'm just trying to figure out the logistics of it. First, this idea of breaking it up: general instructions, closing arguments, specific instructions, closing instructions, versus all one big block after the closing arguments. Does anybody have any views on that?
My position is it should be the standard practice.
Okay, so you don't like novelty here.
Well, I don't like that novelty.
Well, so what's the problem?
If the closings take a total of 2 hours, then we have a morning break, and then the instructions would be an hour and a half,
Okay.
even if they're that long. I don't think they're that long.
Okay, so you'd like to keep it together?
Yeah.
Okay.
I've seen it done obviously both ways. I've seen it done recently, done the novel way. And what I think is nice about it, it just breaks up the instructions. I think listening to instructions for that long is, I think it's just better for them to hear some general instructions about their approach to arguments and deliberations, have the closing arguments, and then Your Honor finishes with a substantive law that they have to apply. I just think it keeps their attention better. It's a little...
That's why judges have started experimenting around with this, because it's a very long time to be talking to a jury. And particularly if I do general instructions first and then go into specific instructions, by the time I really get to the meat of the thing, they've been listening to me for a half an hour and their minds perhaps are wandering. I'm seriously thinking about dividing it up. General instructions, closing arguments, specific instructions. What about the use of this chalk? First of all, I got it, I don't know if it was provided to defense counsel. Ms. Saxo, did you prepare this?
Yes, I did.
Okay. It looks accurate to me. Has, Mr. Shapiro, have you had a chance to review it?
Yeah, I have, and are you suggesting that this be given to the jurors while you're instructing them?
Yes, what I was thinking about doing is giving, before I launch into my jury instructions, refer to this chalk. This is an outline of all the elements of each of the crimes we're going to be discussing, and then launch into my specific instructions so they can refer to the outline as I'm instructing on the various elements.
I don't have any objection to this.
Okay.
I agree. I think it's a good idea.
Okay. And this, I was also thinking about giving them copies of the verdict slip at the same time as I give them the instructions. So when I refer to the verdict slip, I can tell them, they can actually look at it and see what I'm talking about. Because it's a complicated verdict slip. They're to make one choice between the 1, 2, 3, 4, but under 2 and under 4, they have different choices, which they can select both or one or neither. So take a look at the verdict slip. I think first of all, under the alternative theories, we have to make sure it's and or. I was going to put that language someplace, with deliberate premeditation and or with extreme atrocity or cruelty, so that they know they're considering both, and they can mark either or both.
I have an issue with this jury slip, and it comes up typically in a case where the jury, let's say, only checks off, let's say, under first-degree murder, one or the other, and then the court doesn't know whether or not the other theory was rejected, that is, not guilty of the other theory, or whether the jury was unable to reach a verdict on the other theory. So that means that I mean, and this of course is just supposition, but were there to be a new trial, if one of them hadn't been checked off, then the Commonwealth would be able to retry the person on that theory.
No.
Yeah.
No. I mean, I thought my instruction made it...
Guilty or not guilty with respect to each theory. That's the only way the verdict can be clear as to whether the jury was unable to reach a verdict with respect to the theory or reached a verdict of not guilty on that theory.
My understanding, Your Honor, is of the law is if there's a verdict slip of this type and only one theory is checked, the Commonwealth is precluded from then retrying on the other theory.
Yes.
Because
That's not true.
I think that's absolutely true. And my instructions also make it clear they cannot check that unless they agree the Commonwealth has proved its case. If they disagree, they're split, then the Commonwealth has not proved its case and they cannot check that theory. And so, for example, if they disagree, if it's 6 for deliberate premeditation and 6 for extreme atrocity or cruelty, let's assume, then there's no guilty of murder in the first degree. They don't have a verdict on guilty. They have to go to murder in the second degree because they don't have a unanimous verdict on guilty of murder in the first degree. It is basically, essentially has the same effect as a not guilty in the sense that they cannot find him guilty of murder in first degree. They can only consider the lesser charges.
What I'm thinking of in particular are cases where there's a felony murder charge, and under the felony murder charges there are predicate felonies. So it could be murder in the first degree, and based upon or felony murder in the first degree based upon, let's say, armed robbery or armed home invasion. Now, I just recently had a case where the jury checked off guilty of felony murder in the first degree and checked off armed home invasion and didn't check off armed robbery. So then
presumably that defendant was also charged with, in addition to felony murder, was also charged with home invasion and armed robbery.
No, he was only charged with armed home invasion and not charged with armed robbery.
Okay, I think that's apples and oranges.
The point is that that case was reversed, and on retrial, the Commonwealth was able to proceed on an armed robbery.
If you want to, do you have the case citation?
The case is, well, I'm not sure that.
Why don't you do this? If you can send me a citation. I think you're wrong about this. I've never understood that where a jury did not check off one of the theories because they couldn't agree, but did check off another theory, in which case he's now convicted of first-degree murder, then of course it's irrelevant.
I know the case. I don't have it
Okay.
with me, but I will send it to you.
Okay, I'll think about it when I get your case citation. So the verdict slip, the clerk just added the words "and or," if you see that, and we have the 4 choices and a 4-person's signature line and the date. We have the chalk, which we'll distribute along with the final instructions. In the past, where I have not given written instructions, I've always tape recorded my instructions. Some judges actually, even where they give written instructions, also tape record it on the idea if there's any inconsistency, like I add a few words here and there, that the recording controls and that kind of, it's a belt and suspenders kind of approach. I'm happy to do that. I don't anticipate varying in any substantive way from my final instructions, and if I did, I would reprint them. So I don't know if it's really necessary to tape record, but sometimes juries, maybe they like hearing my voice instead of reading the instructions. In other words, give tape recording and written instructions. Any views on that?
I suppose it can't hurt to do
Okay.
them both.
Sure, okay. Then I'll do it. Anything else we need to talk about? So, Mr. Deacon, you're anticipating anywhere from an hour to hour and 15 minutes?
Yes, Your Honor. I'm shooting, to be clear, I'm shooting to come in under an hour. That's my goal. I just know, given the volume of the material, that, you know, I guess what I'm asking is that rather than at an hour in court saying, wrap it up,
okay.
Mr. Deacon, it's sort of...
That you have the
yeah.
flexibility.
But
Okay.
I'm shooting to be under an hour.
Okay, and you're on board with
I'd
that?
like that same flexibility.
Okay. Can I just talk to counsel briefly at sidebar before we adjourn?